about the 14th Amendment on page 203. All criminal prosecutions this is right below concurring opinions. So, all criminal prosecutions is clear both from the language of the amendment and from this court's interpretation. It is equally clear from the cases all decided after Betts versus Brady that the 14th Amendment requires such appointment in all prosecutions for capital crimes. And a little bit lower than that, it's like indented in a little bit smaller font. Obviously, the 14th Amendment cases dealing with state action have no application here, but if they did, we believe that to deprive civilian independence of the safeguards of the jury trial here would be invalid under those cases, as would cases of a capital nature. So that's an excerpt from Brady or Betts versus Brady, and they're saying that like, yeah, this would apply to other things, but it doesn't to this one.
And why didn't it? I was confused.
I don't know. I think it was just like
because it used to. You can go. It used to be like. I keep touching this. Sorry. It used to be like it only applied to capital offenses, but I think this case set the precedent that now it's a right for any criminal offense.
Yeah. So what I think I hear you saying is like the 14th Amendment made the like the right to like have a lawyer. It made it apply to all capital offenses, but it didn't make it apply to all like non-capital offenses. The 14th is what makes the amendments apply.
So going back
and what they decided in this case was that the 14th Amendment makes that apply to all cases.
Okay. So going back to Sandra's initial question, the 14th Amendment allows for the Bill of Rights to be instituted in state governments, not just in the federal cases. So that's why. So, and the Bill of Rights, includes the right to an attorney. So this is one example of selective incorporation in which the Supreme Court is bringing the Sixth Amendment to state courts, not just federal courts. Does that make sense?
Yeah. There was some quotes on 202, like the little indented paragraphs that talked about previous cases that said. And the first one says, we concluded that certain fundamental rights safeguarded by the first 8 amendments against federal action were also safeguarded against state action by the due process of law clause of the 14th Amendment, and among them the fundamental right of the accused to the aid of counsel in a criminal prosecution. And the next one says, the assistance of counsel is one of the safeguards of the 6th Amendment deemed necessary to ensure fundamental human rights of life and liberty. So if these are previous cases, I don't understand how they didn't set precedent that the 6th Amendment was a fundamental right and should be incorporated before Gideon versus Wainright. Does anyone have any idea?
I think they were like I think it's in the name selective incorporation. They were taking bits and pieces of those amendments and applying them to the states, not the whole thing at one time.
There's
They also, wait, she said we said again, or just like refer to
I was
it?
wondering why these cases that they quoted didn't set a precedent.
Yeah, that's a good question, because it does seem like this should be a fundamental right. I mean, having a fair trial is pretty essential to justice in our government. But I read the impact of this case, and the only real drawback, or what could be a drawback it seems, is that it impacted the need of the state to maintain order. So it kind of complicated how states could try people that were accused of felonies or other crimes. That's just what I was thinking in response to that.
What I think maybe it's kind of it's on 204 under the fate of the special circumstances rule. About your question, Lila, of like why it wasn't set as a precedent, I think it's because it's right at the beginning says, in non-capital cases, the special circumstances rule has continued to exist in form while its substance has been substantially and steadily eroded. And then a little further down it says, this evolution, however, appears not to have been fully recognized by many state courts. In this instance, charged with the frontline responsibility for the enforcement of constitutional rights. So I think it's saying, and then below it says the special circumstances rule has been formally abandoned in capital cases. So it's kind of just saying like each case has kind of given the Sixth Amendment a little, like it's given a little bit more attention to like the importance of this constitutional right to an attorney. But it was never formally said like, okay, everyone should have it. It was like steadily eroded by saying like, okay, it's non-capital cases and now it's like special circumstances, like certain crimes. So I think, I don't know why they never set a precedent, but I think that that's what they were doing instead of setting precedent.
Does anyone know like what exactly a special circumstance would be? And like what the rule would say for that?
Yeah.
Because I think they said like, a little bit below, like, well, I don't know exactly what this is, but like, there's a little bit below it that, I was reading like, the fate of the special circumstances rule that it's like the court, I know that is making sense, it's like in the middle of 204. The court has to come to recognize, in other words, that the mere existence of a serial criminal charge is constituted in itself, especially circumstances require the services of counsel at trial and truth. So I think when they were
Could you
like
use that
saying,
again a little slower?
yeah, sorry.
Take your time.
The court has recognized, in other words, that the mere existence of a serious criminal charge constituted itself special circumstances requiring the service of counsel at trial. So I feel like when they were like describing special circumstances, they were trying to like talk about how like these like small like crimes like are now like put under that. Does that make sense?
Yeah, to specify, the special circumstances in the prior relevant cases were either a capital case, so murder, or a case where you were sentenced to death. So if you didn't perform murder, but you had a different case, but your sentence was death, then you also would be
So it's like higher
hired
stakes.
a lawyer, yeah.
Chapin, what were you gonna say? I wanted to read something here from the first page of 199 and the focus on. So in one part it says, in Betts v. Brady, 1942, the court held that in state criminal trials, a defendant is ordinarily not entitled to have an attorney provided at the state's expenses, although defendants must be granted an attorney in special circumstances such as literacy or incompetence. So I think that's probably actually what they're talking about.
Yeah, they also said that if you look on the team worksheet in Powell versus Alabama, the court also said that state courts must appoint counsel whether requested or not when the defendant is incapable of making an adequate defense because of ignorance, feeble-mindedness, illiteracy, or the like.
Could that just be the fact that the defendant isn't like a qualified lawyer? Like I feel like it would be, I don't know what you, because I know like to claim things like mental illness, you have to have very specific things, but like how easy is it to claim like ignorance or feeble-mindedness? Because if I feel like it would be fairly easy.
What I think